Hi, I've been practicing for about 15 years, and I have clients who look over our trusts, and there's parts that they just don't understand. And I have to say, really, a lot of the language it's like Greek. It's like a new language. And so I explain these clauses over and over, but I thought I would put it once and for all in a video so everyone can see these weird clauses. What do they mean? I'm going to break them down for you. These are clauses that you often see in estate planning documents, specifically revocable trusts. So let's dive on in. So the first clause, and when I say clause, I just mean like a paragraph in the trust. So you may be reading over the trust. Maybe your attorney drafted a trust for you and you read it over and you're like, huh? What does that mean? All right, the first one is called the Rule Against Perpetuities. What a weird name to begin with, okay? This is something actually that comes up in a lot of law school exams. So if you're an attorney and you're watching this, you're like, oh, I think I remember that back when I did the bar a long time ago. Well, so what is that? What is the Rule Against Perpetuities? So this is the language that we have in our trust, for example. So you can see it says, any trust created under this trust document needs to terminate 21 years after the death of the last to die of the descendants of my paternal and maternal grandparents who were living at the time of my death. Weird. What is that all about? Well, I'm going to break this down for you. So in California, we have public policy that means we don't want trusts to last forever. We want money to be circulating in commerce and we don't want it to be tied up in a trust. So what we do is we have this rule against perpetuities, which is really, it matches the federal law. Now, there are some states that allow money to be held up in trusts for longer, but in California, it can only be the life of the youngest person living at the creation of the trust, their lifespan, plus 21 years. So usually that turns out to be about 90 or 100 years. So that means if you create a dynasty trust, it would be the lifetime of the youngest beneficiary of that dynasty trust, all right? And then 21 years more. So usually that's about 3 generations. So when the grandchild of the beneficiary of the dynasty trust dies, that's when the money has to be distributed out. It can't be held in the trust again anymore. So really this is a rule against holding money in a trust for perpetuity. All right, the Rule Against Perpetuities. The next thing that comes up a lot is what we call a power of appointment. So to appoint something is really to redirect it. So let's say I have a trust set up for me, right? Say my mom sets up a trust. Thanks, Mom. She sets up a trust for me and she says, upon my death, I have the power to redirect any money that's remaining in the trust upon my death wherever I want. And that's what this language says here. So I'm going to show you the language from our trust. So the beneficiary, in this example, that would be me, has the testamentary, that means upon my death, not during my lifetime, but upon my death, the testamentary limited power to appoint or redirect all or any portion of the principal and undistributed income remaining in the trust, my trust, at my death, among one or more persons, corporations, or entities. But it's limited. So it can't be to me or my estate or my creditors, the creditors of my estate. That means that it can't be, basically, that's lingo that we include so that it can't be included in my estate for estate tax purposes. Okay, so you find that a lot in dynasty trusts, for example. We're trying to avoid having to pay estate taxes at every generation. So now, if I have this power of appointment, what am I going to do with it? Well, I can exercise it. So in this one, I didn't tell you the last part of it, okay? If I don't effectively appoint this, then it goes to my descendants, okay? But let's say maybe I don't have any descendants or I don't like my kids anymore and I want it to go somewhere else. Well, what do I do? So you exercise a power of appointment in the will, or you can do this also in a standalone document. It depends on what the trust says. So it says, I have a testamentary power of appointment over the property in the Ellen Cookman Lifetime Trust, held for my benefit, okay? And I can exercise it in favor of just about anybody. I hereby appoint that property to Scott Cookman, my spouse, if he survives me. And if he doesn't survive me, it goes, I'm sending it to the ACLU, all right? So this would be included in my will. If you have a trust that somebody has set up for you and you have a power of appointment, you can exercise that power of appointment in your will.
Hey everyone, if you like my mom's video, like and subscribe.
All right, so the next weird clause is something called a disclaimer trust. All right, so let me kind of set this up for you. When spouses are married and one spouse dies, everything typically will go to the surviving spouse. Although sometimes people will do what we call an A-B split. And I recently did a video on this, so you can go watch that video if you'd like. But if you don't do an A-B split, everything goes to the surviving spouse. However, sometimes we put in the trust something called a disclaimer trust. So this gives the spouse, the surviving spouse, the power to disclaim or say no thank you to the half of the money that they're receiving from the surviving spouse. This is the language that you might see in the trust. So in section 2 of our 7.02 of our trust, it says, if the surviving settlor disclaims any property that would otherwise go to the survivor's trust, it goes to the non-marital share, and that's administered as provided in Article 9. All right, so now we have Article 9, and this talks all about how the disclaimer trust is managed. And basically, the surviving spouse gets all of the income and as much of the principal as she might need, and then it distributes the way that the deceased spouse said. So it's kind of like an optional bypass trust. Now, let me just tell you, in my 15 years of practicing estate planning, I have seen a disclaimer trust be exercised exactly once. And that was for California property tax purposes. I'm not going to go into it. But suffice it to say, disclaimer trusts, we include them really if the estate tax exemption suddenly plummets for some reason, and the survivor doesn't want to receive all that money from the deceased spouse. But usually the survivor does. So you'll see language in your trust, if you're a married couple, setting up a disclaimer trust, but just assume that it's not going to be funded. We have it there just in case. Okay, now I want to say a few words about a no contest clause. All right, so this is what you'll see in our trust, and it looks different just in about every trust. It says contest provision. If any person attempts to contest or oppose the validity of this trust or any amendment to this trust, then that person will forfeit his or her share, cease to have any right or interest in the trust property, and will be considered to have predeceased me for the purposes of this instrument. So basically that's saying if you have a beneficiary and they object to the trust, then basically they lose whatever their inheritance is. I want to say something about this, all right? No contest clauses are disfavored under California law. California, in 2010 or so, there are some cases that were passed that took the teeth out of no contest clauses. So I often include them in the trust, but it's very difficult to enforce them. Our government basically wants people to be able to contest trusts if there was some problem with it. But I still include the no contest clauses because a lot of beneficiaries don't know that it's hard to enforce. All right, so that they might see that and go, oh, well, I'll take that $20,000 because I don't want to lose it if I contest this. Now, if you have somebody who is not receiving anything in the trust and there's a no contest clause, there's no disincentive for them there, right? They can still sue because they're not going to lose anything that they weren't entitled to in the first place. So just keep in mind that no contest clauses are very limited in their effectiveness. Okay, so the last clause that I want to talk about is something called a spendthrift provision. And when you think of a spendthrift, this is somebody who blows through money, right? They get money and they immediately spend it. So we include a provision in the trust that isn't exactly aimed at that, but it's the same flavor, it's the same idea. Let me show you what the language looks like. It says, no beneficiary may assign, anticipate, encumber, alienate, or otherwise voluntarily transfer the income or principal of any trust created under this trust. In addition, neither the income nor the principal of any trust created under this trust is subject to attachment, bankruptcy proceedings, or any other legal processes. All right. So what this does is this allows the trustee, if there's a trust administration going on and money is about to be distributed to a beneficiary, maybe a child, okay, after parents die, money's going to a child, but that child is going through bankruptcy or they're being sued. Okay, what this allows the trustee to do is to hold on to the inheritance for a while longer. Maybe they're going through a divorce. until that creditor's claim is resolved. And then the money can be distributed to the beneficiary once there's no more creditor's claim. So the spendthrift provision is really to protect beneficiaries from receiving money and then losing it to bankruptcy or to the horrible ex-spouse. So I hope that that video was very helpful for you. If you like these videos, I ask you to hit that notification button, which is, it's the little bell sign on your screen, and that will alert you when we release new videos, which we release every week, typically on a Monday. So thanks for watching, and we'll see you at the next one.
Hello everyone! If you liked my mom's video, don't forget to like and subscribe. See you all next time!